property. Most of our attention is going to be focused on copyright and patents, but I do want to give some quick background on trademarks and trade secrets so at least you have some idea about those topics going forward. We're really just talking about trademarks and trade secrets, the copyright and patents that we're going to push to the future for the rest of the week. So the first question, can you think of some examples of these things? And I'll go ahead and give you a chance to think about that, or you can pause me and think about that. Here we go. Here are some examples. So trademarks, you've got the trademark Nike swoosh. You've got, for those of us who went to the University of Maryland, Fear the Turtle, which is a slogan because Maryland's mascot is the Maryland Terrapins, which is a type of turtle. Trade secrets, sort of the most famous ones are recipes. So the recipe for Coca-Cola is a trade secret. The recipe for Kentucky Fried Chicken for their special batter is another trade secret. There's a few others. Copyright, this is just tons of stuff, books, works of art, software, any number of other things. Patents, you've got pharmaceuticals, are sort of a big one, but also other types of inventions, including, believe it or not, certain cuts of meat. I'll post this example, but a couple years ago, somebody actually patented a new cut of steak, and what they patented was not like steak itself or the cow or anything. It was a process of how to cut. It was called a Vegas steak. Apparently, there was some meat on a cow that had previously just been used to grind up into ground meat for hamburgers, and this food scientist, which is a thing, actually figured out a way to sort of cut the meat and get this new type of steak. So patents are for processes and things like that. And of course, interestingly, you'll note software. This is an incomplete list, but software is one of the few things that can be covered by both copyright and by patents, which makes it particularly interesting. So, here's a clicker question. I'll give you a chance to answer this. You'll get credit whether you get it right or wrong. But where is the legal basis of copyrights and patents in the U.S. established? If you basically read any of the Wikipedia stuff, you'll kind of figure this out, but I'll give you a chance to check this out. And the answer here is actually the Constitution. And it's specifically Article 1, Section 8, Clause 8, often called the Copyright Clause. The Congress shall have power to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. So this is where your copyright and patents, the legal basis in the United States, at least for that, comes from. So we'll return to copyright and patents. Some questions, of course, to think about. Why do we need copyright and patents? And what's the difference between copyright and patents? What sorts of things do they cover? But we're talking about trademarks. So to start with, trademarks, this was covered by common law in Britain before American independence, and then there were American state laws for decades up until independence. There's actually no federal law for trademarks until after the Civil War, and in fact, the first laws trying to deal with trademarks were actually struck down by the Supreme Court at the end of the 19th century for exceeding the constitutional authority that was granted for patents and copyrights. They decided that this was sort of too broad. If you want to read more about this, there's the famous trademark cases. There was finally a Trademark Act passed 1881 after these previous efforts had been struck down by the Supreme Court. And one thing to note, this is carefully worded to focus on interstate commerce so that it'll fall within the boundaries of what's called the Commerce Clause. What this means is that trademarks must be used in commerce in some sort of commercial, profit-seeking activity in order to be valid. I shouldn't say profit-seeking because nonprofits can have trademarks, but it must be used in commerce, the exchange of goods and services. This law was updated in 1905 and again in 1946 by the Lanham Act. Just to note, the Commerce Clause, this is Article 1, Section 8, Clause 3, to regulate commerce with foreign nations and among the several states, and with the Indian tribes. So this is, and of course you can see that how the Constitution showing its age, and with the Indian tribes. We don't really use the term Indian anymore. We're going with Native American, or the Canadian term is actually, I think, more elegant. They use the term First Nations because those are the First Nations of North America, which I think is really kind of a cool way to put it. But anyway, Article 1, Section 8, Clause 3. This is one of the enumerated powers given to Congress, and it's important to note that this specifically deals with commerce because all of the federal law holding up trademarks is based on this Commerce Clause. That means it's only going to protect some sort of commercial activity. So currently, trademarks can be registered with the U.S. Patent and Trade Office, the USPTO. There's two kinds of trademarks. There's registered, where you have the little circled R. There's unregistered, where you have the TM sort of superscript. And actually, 5 years of uncontested use of the trademark superscript, that can help confer what's called an incontestable legal right when you do officially try to register the trademark with the USPTO. So some of the differences between copyright and trademarks. Trademarks are sort of symbols that you're kind of writing. Some things to note here. The protections of trademarks, these are actually restricted to commercial use. So you can't trademark something that's not being used commercially. This is the side effect of falling under the Commerce Clause. Copyright actually applies to any work, even if the work is never used for profit in any way, even if the work is never intended to be used for profit in any way. Copyright applies to things like letters that you might write. J.D. Salinger, author of Catcher in the Rye, was actually famous for not wanting anything ever to be published after he published his masterpiece and a few other things. He didn't even like to have any excerpts from his letters republished anywhere. Copyright infringement now can have criminal penalties thanks to the DMC, the Digital Millennial Copyright Act. Trademark infringement's almost always a civil trial. Company A is infringing on the trademark of Company B, so there's a lawsuit, and then they're going to check whether the trademark is registered or unregistered. Is it registered with the USPTO? What do the trademarks look like, and so on. The one exception to this, there's what's called criminal counterfeiting of trademark goods. So, for example, if somebody's selling, fake Nike sneakers that include that trademark Nike swoosh, that's not going to be acceptable, and that can actually be a criminal trial. So trade secrets, there's actually no federal law that covers trade secrets. About 45 states, as of the last time I checked, which was a couple years ago, had adopted the Uniform Trade Secrets Act, which kind of establishes some sorts of conventions to standardize how state laws are going to deal with these things. But there's still going to be differences between the states. And then, of course, there are states that haven't adopted these conventions yet. So everything's going to kind of vary by jurisdiction. There's no overall federal law, at least in the United States. The three factors that are important to take into account with trade secrets. A trade secret is not generally known to the public. It confers some sort of economic benefit on its holder, and this benefit must derive specifically from its not being generally known, not just from the value of the information, but also from the secrecy of the information. And a trade secret must be the subject of reasonable efforts to maintain its secrecy. So just kind of as a ridiculous example, something is not a trade secret if you make no effort to protect it. So, check out my grandma's secret recipe for porridge in my blog. So you're not making any effort to protect it. You can't then claim that secret porridge recipe of your grandmother is somehow a trade secret. If it doesn't help you make any money, it's not a trade secret. So you can't, try to sue somebody and say, you can't make my grandma's special porridge. This is a trade secret. Only used for non-commercial Thanksgiving dinners in our family. That's not going to have any legal basis because a trade secret needs to confer an economic benefit. And if it's something that's already known to the public, that's also not going to work. So, if Grandma's secret recipe showed up in a cookbook in 1897 and you're trying to claim it's a trade secret, that's just not going to work. Now, of course, copyright and patents, these are just much more relevant and interesting for computer scientists. But I did want to mention trademarks and trade secrets. They are other types of intellectual property. They are important. They are things to keep in mind. But there's no federal law for trade secrets. It's all dependent upon state laws, which are going to differ a little bit. And, of course, for trademarks, these are covered by the Commerce Clause. So these have to be used in some sort of commercial enterprise, which is going to make them a little bit different.